All right, we begin argument in our first case, Quema versus McHenry.
Thank you, Your Honor, and may it please the Court. My name is Joe Colley, and I represent the petitioner, Mr. Mohammed Kaima, in this case. Mr. Kaima was repeatedly raped over a period of 6 years by a Jordanian public official, both on video and at gunpoint. He raises three basic claims on appeal. First, whether there is a nexus between his imputed homosexuality and his past and fear of future persecution. Second, whether the agency weighed the regulatory factors before analyzing his CAT claims. And finally, whether he suffered a permanent and continuing harm that entitles him to CAT relief. The government agrees that this case should be remanded because the agency analyzed each of those claims in the wrong way, but I'd like to take those issues each in turn because we disagree about how exactly that remand should occur. I'll start with the regulatory factors because on that issue, we in the government actually agree that this issue should be remanded.
You're opposing any remand in this case?
We are asking for remand about the regulatory factors, so we agree that the regulatory factors should be sent back, but then we ask that for the asylum claim that the court remand with instructions finding a nexus between his imputed homosexuality and his past.
So you want a remand, but you want us to give instructions on the nexus issue?
Yes, Your Honor.
Can I, about the nexus issue, I'm just having a little trouble tracking the imputation claim because this isn't like a standard imputation claim. You're not arguing that the persecutor targeted your client because he thought he was gay. And you're not arguing that at the time anybody else thought he was gay. And so I'm just sort of struggling to understand the logic of your claim. Can you explain to me how what happened to your client was because somebody thought he was gay?
Yes, so for the past persecution piece, so the reason why Mr. Kaima was targeted after that first abuse, in which that abuse was videotaped, is because his abuser, Abdul, used the videotape as a way to...
I get that, but the videotape wouldn't have worked if anyone already thought he was gay. It seems almost like for this plan to work, for the tape to be leveraged, it has to be the case that people don't already think he's gay. So I think I'm maybe not phrasing my question right, but I really am struggling to understand the imputation part of this.
So the issue with Abdul specifically is not whether or not he thinks Mr. Kaima is gay, it's whether he's using the videotape because of the fear that other people might perceive Mr. Kaima as gay.
At some point in the future.
That's why he's using the videotape as blackmail, as extortion. So he's using Mr. Kaima's present fear of other people finding out that he's gay to continue holding him in submission and continue raping him. That's why Mr. Kaima was targeted for a period of 6 years and why he didn't move on to another individual. He used that fear that others would come to perceive him as a homosexual to continue raping him. And so that was one central reason for...
So what's the protected characteristic?
Imputed homosexuality.
But you just said that's not the reason why the persecutor persecuted him. It's not because of imputed homosexuality. It's because the victim has a fear that the videotape would be shown to other people who might think that?
Well, it's the fear that, so his abuser is using his categorization as an imputed homosexual to continue raping him because of the existence of the videotape. And the fear is that other people will perceive him as a homosexual, that he will be an imputed homosexual, in other words, because of the existence of that videotape.
Does this go to your asylum claim or to your CAT claim?
This goes just to the past persecution for the CAT claim, or excuse me, for the asylum claim. Because on the future side of things, so even if this court rejects the imputed homosexuality categorization for that past piece, there are people who already perceive Mr. Kaima as gay regarding that alternative future fear of persecution, and that he will be subject to discrimination or persecution if he's returned based off of that future fear. In the record, we already have that Mr. Kaima testified that his ex-wife still lives there. And
Is she one of the persecutors he fears?
No, so the fear is whether there will be someone who finds out that he's gay and will come to discriminate against him. And so it's not his ex-wife specifically, but it's the fact that his ex-wife perceived that he's gay shows that there's already people in Jordan who perceive he's gay. And it's important when we're talking about Jordan to recognize the societal conditions there. This
Well,
is a
for
country where...
purposes of your cat claim, you've got to prove that it's more likely than not that Abdul would show up at some point and resume his unfortunate behavior. And I mean, just for purposes of the cat claim, I suppose it's possible that Abdul would do that, but is it more likely than not that he would do that? You have the burden on this point. So I'm just thinking about the likelihood of the future torture, and there are always things that might happen, but things that might happen are not more likely than not to happen.
So yes, Your Honor, that is the correct standard for the cat claim. But just specifically, if I may clarify about that future fear of persecution in the asylum context. So the standard there is whether is as low as he needs to prove as low as a 10% chance of future persecution. And so that is the point that I was making it as far as his ex-wife already perceiving he's gay.
Well,
And
one thing I'm wondering here is why did the agency not address the whole the relevance and importance of the credit card conviction?
Because the board did not make a finding about whether or not that constitutes a particular serious crime, and so without that,
Well, if we remanded, the whole question of the credit card conviction would have to come up, would it not?
yes, Your Honor, and we submitted arguments below, particularly as it regards to the role that his mental health plays on that.
And fraudulent crimes, of which this is one, are generally considered crimes of moral turpitude, and criminal offenses of moral turpitude are in turn considered to be aggravated felonies.
Well, our position below was that, based on the mens rea of the statute, that doesn't constitute an aggravated felony. But once again, the board didn't make a determination about that. So,
But I mean, on a remand, the IJ, if it went back to the IJ, who would have to make findings on the cat claim, but they would also have to address this credit card conviction and whether that made him deportable on aggravated felony grounds.
yes, Your Honor, the IJ would have to address that once this case is remanded, and we don't disagree that that's the case.
So, I mean, I'm just not sure how much you're going to get out of a remand. I don't have any particular reservation about it, but you're going to have to carry your burden as a matter of fact under the cat claim, and you're going to have to a remand wouldn't imply that we thought the board had gotten the nexus argument wrong. We would have to re-examine that. And between examining the nexus argument on remand and examining the credit card conviction and the CAT standard, these CAT claims aren't routinely granted. Things might not work out very well for you. There's a lot of stuff that you're going to have to contend with.
Yes, and we're prepared to do that on remand. And turning back to the asylum claim specifically, because I'd like to focus a little bit more in on the reasons why he has a future fear of persecution. So not only did he testify that his ex-wife already perceives he's gay, both of Abdul and Anas, his abusers, their extended families were aware. They harassed and threatened him during the prosecution. Tribal elders from his village are aware. Prosecutors, the Grand Criminal Court, and the Jerash Provincial Directorate are aware. So
I thought the IJ acknowledged that petitioner told people these two men attempted to rape him, right? And that's what people know. And he specifically didn't say they did because he was concerned about this. And the IJ acknowledged that. And then the IJ was focused on would this persecution that had, allegedly occurred because of a characteristic occur in the future. And because not even the persecutor, for the past persecutor, had this motivation as one central reason in the past, the IJ and the BIA found there was no reason to think that they or anyone else would in the future with this motivation. So what's your response to that?
So regarding those 2 points that the immigration judge made, regarding whether Mr. Kama told anyone that Abdul and Anas raped him, it's kind of besides the point because the videotape exists. So if people learn about the videotape, which shows him engaging
But the BIA talked about that. The BIA already said he says that people might find out in the future because of the criminal case, but I think that's speculative. There's not evidence to support it. So what's your response to the BIA's point that this is speculative?
It's not speculative because Abdul has already done this in the past. He invited Anas along with him to rape Mr. Kama at gunpoint.
But nothing between, if I'm remembering the dates right, your client reported this in 2011 and then left the country in 2014. But in those 3 years, there were no further problems. And then when he, on his own volition, goes back to Jordan 3 times for a month each time, he is approached by Abdul, but when he doesn't get in the car, that's sort of that. So the fact that Abdul did this in the past, there doesn't seem to be a lot of non-speculative concern that he will do it in the future.
Well, addressing that first time gap, Mr. Kama was waiting to cooperate in that prosecution of Abdul and Anas, and once he realized that Abdul faced no consequences and that Anas kind of got off on an easier punishment than he had expected, at that point was when he left the country, and then he came back to achieve 3 limited goals: the first, marriage; the second, divorce; and the third, to finish a final class. And it was on that third and final trip in which Abdul showed up at his university 2 hours away from his village, was able to find him, stalked him, and tried to get him to get in the car with him. And so it was on that point that Mr. Kama realized that relocation was no longer possible, and he hasn't been back to the country since. And so it's not speculative because we already know that Abdul can and has found out where Mr. Kama will be. He works for the government in Jordan, so he has this ability to find him, track him down, and stalk him. And just because he didn't do anything to him physically on this last occasion does not mean that there's at least a 10% likelihood, or that it is more likely than not that he will torture him going forward. I mean, we're talking about his abusers who raped him over a period of 6 years at gunpoint, at knife point. He brought along a friend, and they kidnapped him in the light of day, and had him at knife point. And even after this, even after Anas did receive a punishment, Abdul received no consequences. So this is an individual who has no fear of the consequences. In fact, even after this was reported, even after this first investigation and prosecution, Abdul still showed up at his university 2 hours away, and threatened him and tried to get back into the car, and tried to make him get back into the car. So our position is that this is an individual who's already inflicted severe harm to Mr. Kama and has shown a proclivity to know how to find Mr. Kama and to show up and threaten him again. And so we think that the likelihood of Mr. Kama's future persecution and future torture are both very high. So we ask this court to remand with instructions finding that nexus, and to remand that CAT claim back for the agency to reconsider all of the evidence. Thank you.
Judge Harris, do you have any further questions? Judge Rushing? Thank you. All right, Mr. Nardi?
Good morning, Your Honors, and may it please the Court. Anthony Nardi on behalf of the Attorney General. Your Honors, our position has been the same throughout the course of this litigation before this Court. We believe the Court should remand this case.
Can you speak up, please?
Yes, sorry. We believe that this Court should remand the case back to the agency for further analysis of petitioner's eligibility for asylum, withholding, and CAT protection.
Can I ask you about, it sounds like the parties disagree about whether the agency said enough about nexus. You think they didn't and should get a chance to say more. The petitioner thinks they addressed every argument, but just did it incorrectly. On the CAT claim, it sounds like you all disagree about the theory that past torture could have continuing effects that counts as torture. You disagree about that, but you all agree that the agency failed to consider all the CAT factors. Am I getting that correct?
Correct, Your Honor, yes.
And so I wanted to ask about that, about the CAT factors. You claim the court or the agency didn't weigh his past torture claim, his inability to relocate, or the country conditions.
Your Honor, I think we specifically state that there's no express finding in the record that petitioner suffered past torture, that the conduct he suffered rose to the level of torture in the past.
It didn't seem like anyone was disputing that the conduct was torture, it was rape. And the agency discussed, the IJ discusses the likelihood of future rape. It assesses the past harm, when it stopped, whether he has avoided it since then. That was the basis for for the agency's decision. So it doesn't seem like addressing whether that rises to the level of torture or not was necessary. Then on relocation, page 100 of the JA, the paragraph about relocation, right? So you're wrong about that. And then when it comes to country conditions, the agency, the IJ expressly didn't get into government acquiescence.
Correct, Your Honor.
Right, he flagged. I'm not talking about that because I don't have to talk about issues that aren't necessary to the outcome, right? I've already found there's not a likelihood of future torture, and there's only 2 people who the petitioner claimed would torture him, Abdul and his father. And he said, I've already found neither one of those people is likely to torture him in the future. So country conditions, the evidence of what's generally going on in the country didn't seem relevant, right? That might be relevant to government acquiescence. You point to impunity for crimes against homosexual people. That might be relevant if you were concerned about other people outside of these 2, or if we're talking about government acquiescence in their behavior. But I don't see why the fact that the agency didn't talk about country conditions evidence would be dispositive here.
Your Honor, I would limit my answer. I think with respect to our remand, the only point we agree with petitioners on is expressly that the agency did not make an express finding that the past rapes constituted torture.
Why does that matter?
Well, Your Honor, because under the regulatory factors, it is something that needs to be considered. And I agree with you that it does seem that the IJ, in doing that analysis, she assumed that that had been torture in the past.
Yes.
And therefore, that's why she moved on to looking to whether there'd be a likelihood in the future. The only point of agreement between the parties here is that there was no express finding on that point.
But we don't remand for nothing to happen. I know our court doesn't have precedent on what exactly are the factors that we consider when we acquiesce to a government request for remand without acknowledgement of error. But other circuits do have precedent on that, and none of them just grant a government request for remand without acknowledgement of error if it's going to serve no purpose. They say things like we have to be persuaded that it would be accomplish something, or even some courts set the bar as low as it has to be non-frivolous. but it seems pretty frivolous if you just send it back to like make a better opinion, but you acknowledge that the issue you're sending it back for would not change the outcome.
Your Honor,
If the court has, if the IJ has already, as you just said, implicitly acknowledged this, and it wouldn't change anything, everyone knows that that's torture.
Your Honor, two responses. First, I would say we're not only requesting remand in this case based off CAT. We think there are other parts that would be able to be fixed up on remand. But also, even with respect to CAT, we cite to the Ninth Circuit's decision in Bent v. Garland that looks at the frivolous level for voluntary remand. And we think here it's not frivolous because both we're not conceding error in the ultimate the ultimate denial or granting of relief. We are stating that there was some error in the analysis itself, maybe not particularly in this case of CAT, but we do think there were other errors with respect to nexus and well-founded fear.
So you're not acknowledging error in the bottom line and the disposition?
Correct, Your Honor. We just think that the agency's decision lacks the essential analysis necessary for us to defend the individual pieces of this case that get to the conclusion.
And on nexus, the petitioner disagrees with you on that. He says the agency does, they did say enough and just got it wrong.
Correct, and we think the evidence in the record is equivocal enough that this court should directly remand the case. However, in those directions, instead of expressly stating how the agency should find, essentially stating that nexus has been met, we think the court, as it has in the past, remand for analysis of all of the evidence in the record as to that point. And we acknowledge the result could be the agency denying that nexus has been met, but it would be considering all of the evidence that points to the nexus analysis.
What if we just think the agency didn't do anything wrong? Why would we acquiesce to your request for a remand then?
Your Honor, it's entirely within the discretion of this court to deny the petition and deny the motion and our position on remand. We don't dispute that at all.
Sometimes when we've confronted cases that seem to be a little bit of a mess, we've granted a joint motion to remand and reset the clock to square one and say, okay, here are the parameters, and get this case straight. And so if we grant the remand, it would be possible to put some conditions on it, on the remand. And we would say, I think, that the remand does not imply that the agencies, one way or another, that the nexus finding was wrong. Start it all over. And also, there's no impediment to having the IJ look at the credit card conviction. There's a conviction for credit card fraud out there. There's no impediment to having the IJ and the board look at that conviction and decide whether it qualifies as a crime of moral turpitude, which is a deportable offense.
Correct.
And the remand, a lot of times we would say that we're not remanding, implying anything about the agency's position or the government's position, whether it's correct or whether it isn't correct. But it seems to me that at some point you can conclude that the case is really a bit of a mess, and that the presence of a joint motion for remand is that the parties want to straighten it out. The drawback to the remand is that it just lengthens the time, but you don't see any problem with putting a remand but attaching conditions
Correct, Your Honor.
to the remand and say, start the clock over, but, and address these issues.
Correct, and that's, I think, the main disagreement between the parties here today is that I believe my friends on the other side would have the remand direct the agency to find a certain way as to those elements, and we would say, no, you should remand to the agency for the agency to consider that, looking at all of the evidence in the record.
Is there a joint motion to remand here? I thought it was an opposed motion,
Correct, Your Honor.
right? Which courts apply a very different standard to an opposed motion for remand. The petitioner does not want to go through all of the process again, right?
Well,
He
Your
wants
Honor-
to get some, he wants to win on some points.
Yes, Your Honor. However, I would note that in petitioner's opening brief, at 8 different points, they did also agree that the court should remand this case. They think that that remand should expressly state how the agency should rule on those issues. We think that remand should just state the agency needs to reconsider those issues and fully express their rationale, looking at all of the evidence in the record.
Right, when the parties agree, we sometimes will rule without any reasoning, right? Just do it all over again, even though we don't think you did anything wrong, but the parties agree, so we go along with it. But when the parties don't agree, that's not typically how courts proceed, is it?
I agree those are different standards, and we are clearly in the opposed remand world, yes.
Can I ask you a question? Judge Rushing asked you at the beginning, tried to sort of lay out where the parties agree and where they don't agree. And I had a question on the cat claim. Does the government think we should adopt Muhammad so that, a permanent mental harm, even if there's no likelihood of recurrence of the actual rapes, or not a sufficient likelihood of a recurrence of the rapes upon return, the sort of permanent mental harm might be enough to warrant cat relief?
Your Honor, unfortunately, under Chenery, I don't think I can take a position on that. The agency did not do the analysis of whether or not that is the law. They simply stated that that is not binding on them because it is Ninth Circuit precedent, and they were sitting over a Fourth Circuit case.
Well, I couldn't, are you sure? It seems like they said I was confused. We're not convinced by the respondent's assertion that the severity resulted in ongoing harm amounting to torture. That seems like they did address it.
They then, I agree, Your Honor, and to the extent that this court wants to get into that, we think Muhammad and those other cases are fundamentally different than the case here. Namely, in Muhammad, the harm at issue was female genital mutilation, which clearly has ongoing repercussions. However, specifically with respect to the state action prong, which here the agency expressly did not address under Baghdad. However, in those cases like Muhammad and the other case they cite, K.V. Gonzalez and the matter of YTL, in those cases, there was no question of state acquiescence to the torture because it was either being done on such a widespread basis or it was being done by the state itself. And so I think petitioner's statement that it's simply necessary for this particular harm to exist, that gives rise to the cat claim without any analysis of any other factor, we don't agree with that.
And to constitute torture, doesn't the act have to be against someone in the offender's custody or control?
Yes, Your Honor. The Ninth Circuit cases state that even once that's been done, because of the mental and emotional effects of that trauma, it constitutes torture into the future. We don't think the court should adopt that position.
That it's future. I thought the Muhammad court, it flagged in a sentence or two that ongoing experience may be enough to establish, but it didn't actually make a holding or analyze the requirements for torture.
Correct, Your Honor. It was,
Right. It speculated that maybe one day this might be enough.
it was nebulously dealing with it in
Yeah.
that.
No
Good.
court has so held.
I do not to my knowledge, Your Honor. And I would also note that the K.V. Gonzalez court and the matter of YTL were dealing with the asylum thresholds or persecution standard in the withholding context, not torture.
And that seems really different to me because in the asylum context, there's sort of a range of abuse that might qualify as persecution. But on the torture side, sort of by definition, what is happening to the victim is really, really atrocious and terrible. And it is hard for me to conceptualize how something that amounts to torture would not likely at least produce permanent mental harm. I mean, I'm just wondering if whether this would, if we expanded the sort of humanitarian asylum idea over onto the torture side, whether we're going to end up more or less eliminating the requirement of future, likelihood of future torture.
Your Honor, I agree with that analysis. I don't think the agency has had an opportunity to
Yeah.
fully address that, though.
Okay.
But if there are no further questions, the court.
Judge Harris, you have further questions? Judge Harris? We don't have no
Thank you, Your
further
Honors.
questions. Mr. Birch, you have some, Mr. Colley, you have, he says, Mr. Colley or Mr. Birch? At any rate, you have some rebuttal time.
Thank you, Your Honor. Just a few brief points. So first, jumping into that, the centrality of the reason why it matters that the agency below did not specifically address whether his that ongoing rape was past torture is because that factor in those regulatory factors is the greatest factor that indicates a likelihood of future torture. So that is a central part of the analysis.
Right, but there's the fact, and then there's the legal torture definition. It's like, if the IJ thinks this is not going to happen in the future, whether it's torture or not, then he doesn't need to move on to discuss whether it qualifies as torture, right?
Well, there's no, use the word implicit, there's no explicit acknowledgement. And given the centrality of that factor to the claim, we think that it's important that the IJ.
But why? If the IJ says this is not likely to happen, why does it matter?
Because we can't go off the presumption that they actually did evaluate the past torture if they don't say that they did. And so without that indication at all that they did acknowledge that it was past torture, we may all think that rape is past torture. But
With
without
respect to the torture claim, Judge Rushing made the good point that we've been far more likely to find torture where the individual to be tortured was somehow under the custody or control of the person who would inflict the torture. But in this case, Abdul, or such as he is at large, and the like, but isn't there a danger of expanding cat claims to situations where there may be animosity at large, as opposed to situations where someone would be under the custody of someone else, either some form of confinement or in sharing an abode or whatever? That would be one of the factors that we would look at. And just the fact that someone was at large might do this, we'd be in danger of expanding the basis for a cat claim in these circumstances.
So I don't think there's a risk of expanding the cat claims too much. I think your point does go to the relocation factor as lined up in the regulatory factors. But I think once again, the central point here is that that past torture is the best proxy for the likelihood of future torture. And without the Paxi analysis of the future likelihood of torture, as well as Paxi analysis of the future likelihood of torture, as well as the country conditions, which it also did not really address below. It really only addressed that relocation piece.
Why are the country conditions relevant to whether Abdul or petitioner's father would torture him?
They're relevant to whether Abdul would, it's really relevant to the acquiescence piece, I think, because.
Right, government acquiescence, which if the agency found there's no future likelihood of torture and then expressly said, so we don't have to talk about government acquiescence because we found no likelihood.
Well, I think, once again, it goes back to that past torture and the fact that they didn't explicitly reference whether or not this was past torture. I think without that touchstone, that central point that is kind of the most important piece for that, that all factors kind of get a little fuzzy because of the fact that the immigration judge and the agency just didn't consider that point.
I mean, trying to think how to frame this. The fact that the agency didn't consider whether this was past torture, it does seem to me to be a bit of a hole in the analysis because it meant that the agency never had to sort of think about how horrifying what happened was. And I can see why you might be concerned that that would, the fact that they never have to delve into what actually happened to your client, which was quite horrific, means that it can say something like, well, we don't think the severity, it wasn't severe enough to result in ongoing harm. And so I see it as sort of like a rhetorical absence But logically speaking, I really am struggling with, I guess I'm really just repeating Judge Rushing's question. Given a finding that whatever happened, it's not likely to happen in the future, I'm not sure, like, what would be added by that, logically, doctrinally, what would be added by that discussion?
I think it goes back to the importance of knowing what the reasons were for the immigration judge's decision. So even if it is rhetorical, it's the key piece of the analysis. And so if we're not engaging with that key piece of the analysis, there's no way for us to fully see what the reasons were for that decision and for us to then try to decide whether or not that was the correct decision. And given this severe record of 6 years of rape, not engaging with that evidence does not really help with the analysis. Thank you, Your Honor.
Do you have any questions? We have no further questions. Thank you. We'll come down and greet counsel and move right into our next case. All right, so when you're ready,
Raymond Atkins, Your Honors, on behalf of the Association of American Railroads. With your permission, I'd like to start by trying to unpack our claim of preemption of the underlying state law and why the association should have standing to raise it. ICTA preemption is not really that complicated. A law can be, I know. Let me try, Your Honor. It can be.
I'm not persuaded by your first point, counsel.
So, ICTA can preempt a law either under the express or implied doctrine. The express test is whether it's managing or governing rail transportation. So what you're looking for is evidence of direct regulation of rail transportation. That by its sweep is not intended to capture things that are remote or incidental, but things that directly are regulating the railroad's operations. Now, that test is well established in all the circuits. The only question is whether you call it express preemption or categorical preemption, but that's just a label. The test is the same. If it's not expressly preempted, then you do an implied preemption analysis. And the test there is twofold, whether it's discriminatory or unreasonably burdensome. And you can find that two-part test, Your Honors, in virtually every court that has addressed it. The City of Alexandria case, as well as the Third Circuit, the Sixth Circuit, the DC Circuit, and the STB. Now again, some courts call that as applied, but as you've said, that's just a label. It's basically the same two-part test. So turning to the discrimination prong, the government concedes that it's a freestanding limitation on state exercise of things like plumbing codes, electrical codes, environmental regulations, and the sort, but it just doesn't apply to this type of regulation. I see you have a question.
I'm
Yes,
sorry,
Your
no,
Honor.
I am perplexed at an even more threshold level about
Sure.
this case, because it's a standing case.
Yes, Your Honor.
Right? So whether you are right or wrong about the nature of a discrimination claim, like, I don't even see why that matters. You surely have standing to bring the claim, and the district court held that you don't by saying it loses on the merits. And I'm just finding the whole posture of this case confounding.
Well, you're not, I appreciate that, exactly. This is like a merits case wrapped up in a standards case.
Right, but those are
It-
supposed to be two separate things.
So-
We've said that a million times.
Right, and that would be grounds for you to remand this issue, because, but the reason the court said that we lack standing and that there had to be an individual member to attend is because he ruled that the discrimination clause claim just doesn't exist. And he cited the City of Alexandria case, which I could talk about in a bit. But, so you're right, so that's why it looks like a merits case, it looks like a 12B6 case where it's
But
dismissed on.
I want to come back to what I think Judge Harris was asking you. Do we have a threshold issue here about associational standing? And it seems to me that the whole question of associational standing would indicate that individual railroad would have to be involved. And saying that an individual railroad should be involved for purposes of associational standing would seem to feed into the argument that the state is making, that these should be resolved on a crossing basis rather than in the aggregate. So there's a threshold problem you have about whether a trade association can bring a claim or whether you need to await for standing purposes a situation where a particular railroad is faced with a particular application from a broadband provider, and the railroad, rejects it, and then it goes up to the State Corporation Commission and everything. But then it's clear that standing exists in that situation, but I have a greater reservation about whether standing exists here, and I'm wondering whether, just speaking for myself, whether you need to satisfy me on that point
I hope to, Your Honor.
before we get
Yes.
into some of these mega issues.
That is unequivocally the issue that's presented, is do we have standing to present these two challenges? And that's why I started with discrimination, because, Your Honor, we don't need Norfolk Southern or CSX or any individual railroad's participation. If the law is discriminatory, it's preempted, full stop. And so we don't need an individual application. Every application is going to be discriminatory. It's this
Well, all right,
bespoke.
if I were to grant you that, if it's discriminatory, it's preempted, and then I gather you would say if there's an undue burden, it's
Correct.
preempted.
Correct.
And the only, and you want to resolve all these things in the aggregate.
Correct.
The state makes the point that as far as discrimination is concerned, there's no discrimination because there's no comparator. The state is saying that,
That railroads are unique.
you're saying that the eminent domain power is being applied in a discriminatory fashion to railroads because no other landowner is required to do this expedited process. So it's unique to you.
Correct.
But then the state comes back and, in response to your argument, and says, okay, it may be unique to you, but railroads are unique, that there's no comparator because there's no other landowner that has tracks going through with a broad implication, a public implication. And so they're saying, all right, no comparator, no discrimination.
So you-
And then they're indicating that there is no unreasonable burden because the statute contains all kinds of defenses that the railroad can offer with respect to public safety or inadequate compensation or what have you. So in light of those, in light of the statutory defenses provided to the railroad, that relieves the undue burden. And So
let me
those
not-
are, you've gotta grapple with that, it seems to me, if you can get past associational standing.
I totally agree. That goes to the merits. There's two, like, commonplace defenses to discrimination. One is that the railroads are unique, or the other one is that if there are similarly situated property owners, that they're burdened by a similar set of regulation. That's the analysis that, say, for example, the Third Circuit applied in the New York Susquehanna case, the Jackson case. Those all go to the merits. They don't go to our standing to present this challenge. And I'll give you an example of somebody who's similarly situated. If you're familiar with Northern Virginia, you got the toll road. It's a privately run stretch of highway that runs from Dulles all the way up to Leesburg. They're not burdened by this yet. They're a continuous stretch of property that broadband providers can't cross unless they go through the state general eminent domain statute. So we know that that's our burden.
This gets back to another point I'm making, and that is, can we tell that something, there's something about this case that the state is saying is premature. Maybe it's a ripeness issue, maybe it's not, but there's a prematurity issue. And if this statute is an undue burden or places an undue burden on the railroads, can we resolve that on a speculative basis, or do we need to see how the statute works out in practice to see whether, as a practical matter and in light of experience, there's an undue burden on the railroads from this expedited process? Why shouldn't we wait?
So, okay, that's the unreasonable burden challenge, which is separate from our discrimination challenge. So I don't want to leave discrimination without satisfying the court that we don't need individual participation, and all of these defenses go to the merits. They should not go to the core right of the association to present a challenge that a law is preempted because it's discriminatory. And if you agree that that test does exist, see City of Alexandria, then it was a mistake to dismiss on standing on that grounds. But now let me turn to unreasonable burden, which is a second prong of the implied preemption doctrine. Here, the core concern of the AAR is we're bringing sort of a cumulative burden type of analysis to this case. What we're saying, we have two core allegations in the complaint. One is that there's insufficient time. 35 days is just not enough time for the railroads to do the kind of safety analysis that they need. That's our allegation, which should be taken on face value as being accurate until it's tested in the merits process. The second one is that these are unmovable obstructions on the railroad's right of way. So before they come in, the railroad's right to use its property is paramount, but after the broadband company comes in and gets an easement, their rights become paramount. And it's not one-off, Your Honor. It's not there's one case or there's two cases where it's the burden flows from the cumulative effect of that. And it's important for the AAR to be able to at least present that challenge on the merits and have standing to raise it. Whether we win, Your Honor, that's our burden. We have to demonstrate.
I know, but aren't you asking a lot of us at this stage to say?
I don't think so, Your Honor.
You're asking us for a facial invalidation of the statute based on an implied preemption theory, and isn't that asking a lot of us at this stage of the game?
I'm not asking you to rule on the merits, Your Honor. All I'm asking you is that the association has standing to present the challenge. If it's discriminatory, it's preempted. And that should be, and then the whole statute is, and it's not done on the express because they're not directly managing or governing rail transportation. It's done under the implied preemption doctrine. And there's no reason that we have to look bring an individual case, because in every instance it's going to be discriminatory.
That might be right for the discriminatory prong.
Yes.
You can challenge it on its face.
Yes.
But when it comes to the undue burden argument, you're saying in the aggregate, the burden will be undue on railroads, that if you consider all the applications that will be granted,
Yes.
That's saying consider future applications individually and then aggregate them, and we have standing to bring that claim.
Right.
Why is that true?
So I'll point you to it's intrinsic in an unreasonable burden analysis, Your Honor, that you are going to consider the cumulative burden of this law. So examples might be when the Supreme Court said that you can't regulate train length. They looked at the cumulative burden on the railroad industry from having that type of regime imposed on them. Similar example would be when the District of Columbia said, we're going to require you not to route hazmat within 100 feet of the capital. The analysis that was done was, what's the cumulative burden on the railroad industry? If it's not just one application of the law that hurts an interstate rail network, it's the repeated application of the law. So,
And it's that is it not also that it always will be that burden? So, I mean, your argument
Yeah.
would have to be, right, 35 days would in no case ever be enough time.
that's the allegation in the complaint, Your Honor, which I think you need to take on face value, that 35 days is not sufficient.
But if it proves to be an undue burden in practice, is your remedy not to go back to the state legislature and have them amend the statute and?
Well, I hope not.
Wait a minute, there may be a political angle to this, that you go by and say, here's the evidence we have, this is proving to be an undue burden, you need to amend the statute and relieve us from this expedited consideration. I mean,
I'm sure the railroads would undertake that conversation. They talk to the state's legislators all the time. But we have a fundamental right. If it's unreasonably burdensome, it's preempted by federal law. We don't need to go and ask them to change it, to conform it to what's required of the Constitution. We have a right to go to court and have standing to present our argument. I appreciate, Judge Rushing, I really do appreciate that the cumulative type of analysis is much more difficult than just say there's a particular crossing where it's just egregious, where they're telling us we have to shut down the railroad for like 3 months in order to do this crossing. We'd argue that's unreasonably burdensome on just looking at that one crossing. But what we're here today to try to defend for the AER is its right to at least present the cumulative burden challenge on the merits. And so if you think it's going to be a tough road, we're willing to. We should have at least have standing to present that challenge and not be told that the whole theory is inapplicable, that theory of unreasonable burden cannot be presented by the AER. And that's what that's the basis.
let me just ask you a practical question. How many
Sure.
crossings are there?
Oh.
How many broadband applications for a crossing are there in any given year? Is there an average of them? Are we talking about dozens or hundreds or what? How many?
I'd be speculating a little bit. I believe it's hundreds, Your Honor. I'll ask my colleague too if we know in the record, if that's in the record. As you can imagine, the railroads are everywhere. They have so many of them, Your Honor. That
How
they set-
many are there? Do you have a number
No.
for me?
No.
Well, I mean, how can you say it's an undue burden when you won't tell me what the number of broadband applications
So
are?
the key question is how many places can they cross us? And I can tell you that there's lots of public crossings and there's lots of private crossings and there's lots, there's so many of them, Your Honors, that the railroads have set up a whole process to process these applications to assure themselves that it's done safely and that it's done on and without impeding their ability to grow their network. So one of the reasons these permanent obstacles are a burden, Your Honors, is because the railroads have to be able to double track and single track and add sidings. And if they don't have a right to move this cable line once it's in place under this regime. State's response to that is, well, you can go in and ask the commission for permission to relocate the line. But that's just jumping out of the fire and the pot into the fire, Your Honor, because the law is really clear that there should be no role for state regulatory agencies in deciding where we put our sidings, how we put our sidings, whether we do an industrial league. All those railroad questions about how we operate our property.
If you can't process the application within the expedited timeframe, what's the remedy there? What happens?
So we have 10 days to ask for additional information. They have a few days to respond. 35 days after that, we
But
have.
can you petition the commission for additional time?
No, well, we can go to the commission, but the commission has 3 different standards by which they can grant it. We'd actually have to demonstrate in that period of time that there's a serious safety problem. And if we haven't had enough time to do it, Your Honors, that's not an adequate remedy, is to go to them.
But if you need the additional time under this statute, can you get it?
It doesn't appear to be one of the 3 prongs by which the commission is authorized to. We have to come to them with a showing that there'll be a severe safety problem within 35 days of the request. And as you can imagine, Your Honors, the railroads, I see my time's expired, I don't want to.
No, go ahead.
Thank you. So that's our allegation, is it's insufficient as a matter of timing. But But I would say, Your Honor, the other core allegation on unreasonable burden is that all of these permanent placing, like, AT&T comes and says, I want to cross here. That's not going to unreasonably burden a large network like Norfolk Southern's or CSX. Then they come and they're down the road, and then you got another one down the road. This is a death by 1,000 cuts type of argument, where all we're asking for as the association is the right to present it on the merits to a federal district court judge, and not be told that you actually have to show that one cut is so deep that in and of itself is an unreasonable burden, but 1,000 such cuts, and if we can't show that it's reasonably likely to happen, Your Honor, then we're gonna lose. But we should be able to get to the merits of the case.
If we were to invalidate the statute facially, where does that leave the state and its interest in providing broadband access to a wide variety of rural communities?
Right.
I mean, are they left high and dry because you can just take your own sweet time in approving the application?
No, I think the obvious solution here, Your Honors, was just to add broadband providers
But
into the normal eminent domain statute, which they're currently they're not part of. So that, and then we would be like.
But what incentive is there in the absence of the statute for you to act promptly on the broadband application?
Well, Your Honor, if they have a right of eminent domain under the generally applicable eminent domain statute, which requires fair market value and an assessment of public use, then we would be in the same situation that any property owner is in. If they come up and they negotiate, we know that there's a backstop of a legal remedy under state law, which is generally applicable to all property owners. My question to you, Your Honor, is why should the railroad industries be the only ones burdened by a bespoke, hyper-accelerated takings regime that has fixed caps, unlike any other property owner in the state of Virginia? That runs right afoul of this anti-discrimination problem.
But aren't railroads unique
No.
among the property owners in Virginia? I mean,
No, Your Honor, the property is property. They own it in fee simple. Why are they unique? Why is a railroad who have a lower property interest than a farmer who doesn't want broadband crossing their property, or a road, or any
what other kinds of crossings are you dealing with other than track crossings?
Anytime they lay cable, they have to cross somebody's property, Your Honor. I'm not a cable line property expert, but they have to move. They have to run the cable, so they have to cross property owners, farmers, states, utilities. I don't know the full scope of people, but what I do know is the railroad community is the only community that's burdened by this particular regime.
Can I ask you a question? I understand your standing arguments.
Yeah.
If, just hypothetically, say, I think, yeah, you have standing to raise these claims. If we thought we should sort of vacate the standing holding and send it back, like, what do you expect would happen, given that the district court has already said what it thinks about the merits?
So,
Do you think it would hold it under
so-
Pullman?
No, I don't. Well, I don't think if you send it to just the discrimination, if you send it back because you say it's a viable claim, that's the whole reason the district court rejected it. So the district court would then have to engage.
Right, but that would be us reaching the merits. Like, we say, oh, no, that is a viable claim. I'm trying to sort of hypothesize a ruling that just said, viable or not, they obviously have
Oh, yeah,
standing
so
to raise it.
Yeah, I do believe, and I struggled with this because of the weird posture of this case, is that since his standing analysis is premised on his ruling that it's not even viable at all, that you can't present it, I do think you have to reach that issue. Not the merits of it, not saying whether, as applied to this context, whether it's preempted under the discrimination prong. You have to at least say that the prong does exist, it does apply to this type of
But
regulation.
we have to do that for this to be worth your time.
Well, I think
Because
you
like
also-
technically, as a matter of standing, again, we usually don't reach the merits. We
Right.
would just say,
It-
there's no reason.
So hopefully what would not happen is you'd send it back and we'd get a 12B6 ruling that
That is-
there is no cause of action, and then we're back here on appeal
Yeah,
with
that's
the
what's so
exactly the
weird
same
about this
conversation. That's
case,
why-
right?
Yes, so that's why I am recommending, Your Honors, reach at least indicating that that we, the association, can present a challenge of whether it's both
But if we
discriminatory.
hold you have standing in this situation, are we opening the door to federal courts that for trade associations to come in and press the association's agenda even though there hasn't been standing even though there hasn't been an involvement of an individual member of the association experiencing some sort of concrete injury. I mean, are we just opening the doors to the lobbying community and to
So,
interest groups pushing an agenda without concrete injury on the part of one of their members? You
So-
see my concern?
yeah, I absolutely understand your concern, Your Honor, I unequivocally. And I would just say two things. One is, I don't think you're throwing open the doors. This is a specific question of whether the Association of American Railroads has a right to bring a challenge under a very specific statute. But I would also observe that there's no question below that the railroads were injured. Like, the injury, in fact, analysis.
Isn't that prong one? I
That's
thought the
prong- that's
parties
abs-
agreed that
Oh,
the
yeah.
individual members were injured and could sue on their
Correct.
own.
That's right.
Okay.
So this is not a case where we're ginning, there's a concrete injury, as was decided below. I've gone way over, I haven't touched on takings, but I'd be happy, I think that's been well briefed on it. I don't have any reserved rebuttal time, so I just appreciate the court for your consideration of
Hold on
this
a
case.
minute, I want to make sure
Oh.
that my colleagues don't have further questions.
Of course, Your Honor. Thank you very much.
Thank you.
Good
Ms.
morning,
Mayley,
Your
I'd be
Honor.
pleased to hear from you.
Good morning, Your Honors, and may it please the Court, I'm Erica Maley, representing Jamal Hudson of the Virginia State Corporation Commission. The District Court correctly dismissed this suit. The Association of American Railroads lacks associational standing for any as-applied ICTA or takings claims. These claims require a fact-intensive, individualized analysis that necessitates the participation of individual railroads.
Can I ask you a question about that? On
Sure.
page 26 of your brief, and this is about the takings clause, you point out, and you put it in italics, they're only looking for facial relief. There's no request for damages. There's no request as to any particular taking. This is just equitable relief, no damages. That is what the court says in Worth versus Selden. That's like the paradigmatic case where you don't need individual members. All we're looking for is a facial relief, a judgment that this thing on its face doesn't work. So why do they need individual members?
They don't for facial claims, Judge Harris, and I'd like
But
to.
as you point out, that's what they're bringing, so why did the district court say they didn't have standing?
Well, what the district court held was that a facial claim fails as a matter of law.
Right, but how can he do that when the question is standing? We have said so many times, and the court has said so many times, those are two different inquiries. And for standing, you assume the validity of the underlying claim, and then you figure out, has a person been injured? Do you need the members? I just don't understand. Did this get argued below as a standing case, or did everyone just jump right to the merits?
It's both, Your Honor. It's standing for as-applied claims and merits for facial claims. We don't dispute that an association can bring a facial claim, but a
Okay.
facial takings
Do
claim.
you dispute that the district court held that they couldn't because it said, I'm dismissing this claim for want of standing?
It dismissed the claim for want of standing because it held that a takings claim for lack of adequate compensation can't be brought on a facial basis. So the only valid claim would be an as-applied claim, and an as-applied claim lacks associational standing. It's actually quite similar to the Rent Stabilization Association case that we cited in our brief from the Second Circuit that also involved an association seeking to bring a takings claim, and the court there similarly held you can't bring a facial takings claim because it's not a situation where there's no application of this law that could be constitutional, and you can't bring an as-applied claim because takings claims can't be brought as applied without the participation of the actual individual owner who can demonstrate the necessary facts about the property being taken and its
All
value.
right, but that's with, did you have further questions on this point?
I mean, basically, as I understand it, you are saying perhaps the district court shouldn't have called this standing, but like, what's the label?
As to the facial claims, I think it's better understood as a ruling on the merits, that no facial claim it can survive legally. As to the as-applied claims, it is a standing issue, Your Honor. The as-applied claims require the participation of individual members and thus can't be brought under associational standing.
And is that because, you know, the court has told us that whether a challenge is facial or as applied, it's not a matter of pleading, right? So when the court looks at a complaint that brings a claim about a statute, the court considers this might be a facial challenge, this could morph into an as-applied challenge down the road if the evidence doesn't come in to support a facial claim, right? So the court has to consider that whole universe, which I think, I read the district court to be attempting to do that and saying, I'm not just limiting myself to looking at, did they plead a facial claim, but I'm also going to consider, like, could they pursue an as-applied claim? And as to that, there would be no standing, right? And then facially, this doesn't go anywhere because it's a takings claim and you have to be individual.
That's exactly right, Judge Rushing. And ordinarily, if a complaint can't state a facial claim, it could still proceed past a motion to dismiss on an as-applied basis, but
Right, that's why courts don't usually grant motions to dismiss based on like failure to plead a facial claim because it can change over time. You're not limited to that, but the court went on and did that as applies analysis and said, well, it's an association, they can't bring that.
absolutely. And that's even though the only claims and the only relief expressly sought is complete facial invalidation of this statute. The court also went on to consider, could there be a valid as-applied claim, and concluded that any as-applied claim here would fail for lack of associational standing because both the takings analysis and the ICTA preemption analysis is a very fact-intensive as-applied analysis.
I totally understand that point on the takings clause side. I'm grappling more with the preemption, the sort of non-express preemption side, because saying that it's fact-specific doesn't by itself mean individual members have to be there. Like, I think it would be fact-specific to figure out whether this statute unduly burdens railroad transit. But we don't ask, does it individually, that's not a crossing by crossing inquiry. It's just, how does it affect rail transit? And so I do see that you would have to look at facts, but I don't see why individual members would have to be part of the litigation.
Well, for the undue burden, it would require a crossing by crossing analysis to determine is that crossing creating a burden on rail transportation? And that's what courts have considered this in the Surface Transportation Board a number of times, specifically with regard to laws that govern railroad crossings, because lots of traffic utilities routinely need to cross railroads. And they've said those laws are not preempted unless the particular crossing either impedes railroad operations or poses safety risks. And if that standard's not met, then they are preempted. So that requires
But
looking.
I feel like if the claim is more like, and I'm not saying this claim prevails on the merits, but it's more like, I'm looking at this statute, it says 35 days, that's just unworkable as far as rail transit goes. That's not like a crossing by crossing inquiry. I totally understand your argument for why you would not prevail. I understand arguments for why it's premature. I just don't get why it matters whether it's AAR bringing the claim or a railroad bringing the claim.
Well, Judge Harris, I think this ends up being a similar situation to what we were just discussing with takings, which is if you're looking at this as being a facial categorical claim of preemption, we don't dispute that that type of claim can properly be brought by an association. However, this law is not within the scope of ICTA's categorical express preemption. And once you're beyond that, once you're talking about implied preemption and burdens, that's a very fact-specific analysis.
Well,
Has to
maybe
be-
so, but the whole reason for the statute and the ICCTA was to protect railroads against, was to provide a certain degree of uniformity to the commercial lanes and the channels of commerce in this country. And the whole idea that the railroads would be undergoing 50 different state regimes, some with expedited proceedings, some with one set of conditions with regard to crossings, and other states with other sets of conditions on crossing. I mean, there's a place for disuniformity in our federal system, but when you read the ICCTA, Congress, it seems to me, was after a certain degree of uniformity. And to have the railroads fighting all 50 different kind of state regimes in terms of broadband applications or other problems involving crossings may seem to go against the grain of the statute. Because if you look at it, that they want a certain degree of uniformity with regard to rail transportation, that it cuts against this as applied theory that you're talking about, and it argues the uniformity Congress sought to achieve argues in favor of aggregate determinations rather than as applied determinations. I mean, you've got to grapple with this federal statute and whether it contemplates aggregate decision, aggregate actions on the part of the railroad, that they can bring aggregate challenges because the disuniformity is almost by definition under the ICCTA would be, the as-applied challenges would almost be definitionally at odds with Congress's purposes in the ICCTPA.
Judge Wilkinson, if I can unpack this a little bit, certainly the ICCTA is concerned with uniformity for railroads, and there is certainly two categories of state laws that are always considered as disrupting that uniformity in problematic ways, and that are always going to be categorically preempted, but crossing laws are outside that scope. And so those laws are laws that deny a railroad the ability to build or continue railroad operations, and laws where a state is attempting to directly regulate matters that the
Well,
service...
where do you make the point, you make the point that, oh, well, these crossings are de minimis, and they're nothing but licenses, they're not easements, and, you know, I'm not sure. I mean, a license is something that has a termination date, and an easement is more permanent. And this doesn't necessarily seem to me to have the characteristics of a license. It seems like the crossing is more of a permanent thing in the nature of an easement. So why do you say this is so de minimis as to be outside of the purview of the ICCTPA?
It's outside the purview of the ICCTA's express categorical preemption. And so any preemption has to proceed on an as-applied analysis that considers whether a particular crossing either impedes railroad operations or poses a
Where do you
safety
get
risk.
that in the language of the statute?
That is the language from STB decisions. It's set forth in the...
No, I'm talking about the statute.
From the statute, it's implied preemption. So it's not in the language of the statute. As to express preemption, a number of courts have held that crossing laws aren't within the scope of ICTA's express preemption provision because the language of the statute is a regulation of rail transportation and a regulation of something that's going under the tracks, over the tracks. The rail transportation continues. So it's not a regulation.
Not necessarily during the period of construction.
Every court that's considered this issue has held that railroad crossing laws are not expressly preempted by ICTA, and the Surface Transportation Board has consistently held the same. Now, they can be.
Have some of these other cases dealt with a situation that's comparable to this in terms of expedited review?
I don't recall a
What was
case.
the setting for these other cases that said, that held that all of these things are de minimis?
It's not necessarily that they're de minimis, Judge Wilkinson, it's just that they're
Well,
not
you're saying
expressly
you're saying
preempted.
they're not interfering with railroad transportation, so that sounds a lot like a de minimis test.
I'm saying that they're not preempted unless there's a fact-specific showing that they are interfering with railroad transportation. And this has been considered in terms of
Well,
all.
why wouldn't they? I mean, you know, you read in the newspapers all the time about train delays and Amtrak trains being behind schedule and all the rest, and I'm not sure why construction of railroad crossings might not provide, you know, might not constitute some kind of cognizable impairment of transportation.
In a particular application, perhaps they could, Judge Wilkinson, and then that particular application would be preempted.
Okay, but litigating application by application after by application, and having each application be a potential candidate for SCC review, isn't the burden of litigation substantial on the railroad?
I don't think so, Your Honor, and I think in a number of ways my friend is misunderstanding how this statute will operate. For instance, claiming that this is a permanent, immovable taking. Nothing in the statute states that, and in fact, if it did become a safety issue, if it did become an impediment to construction later, the railroads can require the broadband companies to
Counsel,
move the line.
To the extent that you and your colleague disagree on what the statute means, and that's just one of several places where you seem to disagree, the meaning of the statute is before the Virginia Supreme Court now.
Yes, it is, Your Honor.
So we will get news soon from the Supreme Court of Virginia about what this statute means.
Yes, we will. The Commonwealth is going to be filing its response brief in that case on Friday this
Okay.
week, and it raises exactly those same questions. So it's our position that this court can affirm on the basis the district court ruled because associational standing is lacking. If this court were to disagree and find that it needed to reach the interpretation of certain provisions to properly dispose of this case, then I do think it's very relevant to note that the Virginia Supreme Court's considering those same questions right now. It's the same ICTA preemption claims, the same takings claims, and even takings claims under a more demanding standard of the Virginia Constitution are
Well,
currently
nobody's
pending.
taken anything at this point.
No one has taken anything at this point, that's correct.
But the court's going to consider, the Virginia Supreme Court will consider this argument that these caps are, at least as to the $0 and the $1,000 caps, that those are immovable.
Yes, they're considering, that case does involve the issues both as to whether the licenses or easements are immovable and also whether the compensation provisions are caps or, as the commission contends, should be interpreted as default amounts that the commission has the power to increase as necessary to provide adequate compensation. And so I'd like to also briefly discuss the discrimination test. I think it fails for two reasons, and perhaps the simplest of those reasons is that they have not shown that there is discrimination because they have not shown that there is a comparator who's similarly
But
situated.
that's not what the district court said, right? The district court said there's no such thing as a discrimination claim, so you lose that on the merits, and therefore you don't have standing.
The district court held that the discrimination claim is part of the police powers exception, which is part of the express preemption test, and that the express preemption test doesn't apply to railroad crossing laws. Now, we think that's.
So the effect of the district court holding was, even if this discriminates against railroads, that's not a
The
problem.
discrimination prong does not apply
Doesn't it seem weird to
here.
read this statute? I mean, I don't want to repeat Judge Wilkinson, but it seemed to me the one thing that was clear from this statute was that localities were not supposed to be able to single out railroads for less advantageous treatment.
I think that the main thrust of ICTA preemption is to make sure that states can't interfere with the operations of railroads, and that it's not primarily concerned with discrimination, except to the extent that the discrimination does interfere with the operations of railroads. And so part of the issue under there, if it's a free-floating requirement, there can't be any discrimination against railroads, it would seem to sweep considerably beyond the main thrust.
Are there ways in which Virginia seeks to discriminate against railroads? Like, what are you worried about? Are there things you want to do that would be discriminatory against railroads but would not interfere with their operations?
Well, I don't think we're saying that we are discriminating
No, I know
against
you're not,
railroads.
but I'm wondering what the sort of state's interest is in this argument. Or does the state have things in mind that it currently does that discriminate against railroads, but in your view, doesn't actually have any bad effect on
I mean, I'm
rail
not
transit?
aware. Of course, our
Okay.
friends are claiming that this law discriminates against railroads.
any others, I
But
should say.
perhaps the simplest answer to this question is to say there is no discrimination here because railroads are in a unique position, and that's due to the nature of their property makes them a unique obstacle to broadband expansion.
When it comes to discrimination claims and comparators, like, we don't usually say that can be resolved on a motion to dismiss. That seems like a fact-intensive argument you would want to have in front of a district court.
Well, I do think, again, it's our position that the discrimination test is actually part of the express preemption provision, which is inapplicable, and that so that it's not this freestanding facial claim at all. But if the court were to disagree, I think they still have to plead enough facts in the complaint to show that there is a similarly situated party being treated more favorably, because that's the definition of discrimination. And they haven't shown that another party is similarly situated, and railroad property is in very long contiguous strips. And so if you're trying to expand broadband internet access, especially to rural communities, which is the key goal of this statute, railroads pose an obstacle to that no other landowner does.
So it seems to me that whether we're dealing with express preemption or implied preemption or the state police power exception to this or that, and then the discrimination question and the question of undue burden and everything, that it in a way, all of these different intersecting questions, seem to boil down to a matter, I'm just thinking out loud because I think this is a very interesting and close case, but it seems to boil down to whether an as-applied challenge is the way to go about this. Okay, that's all tracks lead to the question of whether there's an as-applied mechanism to this. One of the problems I have with this is that when we are asked to strike it down facially, we're almost making the judgment that this is an undue burden, and we don't have the facts before us. And so I'm just, again, thinking out loud, is the way to get the facts before us to see how the as-applied challenges work out in practice, and if it's difficult, if they do pose an undue burden, one way to remedy this is to go back to the state legislature and deal with it in that way. Another way, it seems to me, is to press the State Corporation Commission for broader rulings. that have a precedential effect. So even if we were to go if we were to agree with you that the as-applied route is maybe what we should do at this very early stage to avoid in engaging in speculation on what might be a legislative matter, that doesn't cut off the fact that the state legislature and the state corporation commission and everyone else can profit from experience, and to see whether this expedited review situation does in fact result in snags for railroad transportation and the rest. But the qualms I've had is that we're being asked to do an awful lot at a very early stage. And I'm a little bit uneasy with that. And so I think there's a good bit to what you say about the as-applied challenge, but I'm also sensitive to the fact that Congress had an overriding goal in mind, which was not to see the railroads snagged up in a bunch of state legislative squabbles that imposed different burdens on what is by its very nature an interstate enterprise. So, I mean, your opponents are not without arguments. Neither are you. But the problem is I'm asked to speculate without many facts.
Yes, exactly. I see my time's expired, but if
No, go
I could
ahead.
respond briefly, I think that's exactly the problem here, and that's why facial claims are so disfavored. They're asking to completely wipe this statute off the books, even though it may have many applications that won't pose any problems for railroads. And it's better in this situation to wait for an as-applied challenge, and there are already as-applied challenges pending, both before the Virginia Supreme Court and in federal district court, which has been stayed waiting for the Virginia Supreme Court interpretation that will have more of a factual basis. But the Corporation Commission believes it's not going to be nearly as problematic in practice as our friends are fearing, that the statutes can and should be read harmoniously to avoid applications that are going to have burdens on railroads.
Well, and it does seem to me that the State Corporation Commission, through its decisional law, can take significant steps to minimizing the burdens on railroads, and the statute authorizes them to do so.
I completely agree, Judge Wilkinson. In the Corporation Commission, the railroad can petition on the basis that a crossing would pose an undue hardship. If a crossing would unreasonably burden a railroad within the meaning of the ICCTA, then it would also be an undue hardship under the meaning of the statute. And so the Corporation Commission is very aware that these statutes should be read with a backdrop of the federal law in
The Corporation Commission is not precluded from talking about burdensomeness in class terms, that this kind of application under these circumstances are unduly burdensome. And it's got authorization from the statute to do that kind of thing.
It does, yes.
Judge Harris, would you do? Judge Rushing. All right,
Thank you, Your Honors.
thank you. Mr. Atkins?
So I went way over on my time, Your Honors. I just want to answer one question that you asked me, and then any other questions from the court, which is Joint Appendix, page 21.
So I'm going to come back to
I just want to say it's hundreds of crossings.
Let me just say that
since
you
2021.
are asking us to take on faith the fact that this statute imposes an undue burden upon railroad transportation. And yet, we don't have the facts really to make that sort of, to make that kind of judgment. We're just dealing with a hypothesis that you're presenting, and the hypothesis is devoid of actual factual basis. That is the problem I'm having.
I understand, Your Honor, and the reason there have been no facts developed, Your Honor, is because we've got dismissed on standing grounds. So you need to look at the allegations that were set forth in the statute. On discrimination, which I think is our strongest case, does not require the participation of anyone. You know, you can see Joint Appendix 32, Joint Appendix 20, on information and belief, no Virginia law subjects any other class of property owners to the kind of quick take easements contemplated, let alone on such limited grounds to resist the taking and burden shifted to the property owner. Broadband provider, we allege that broadband providers need to cross non-rail property too. So the allegations are all there in the complaint, which should have been sufficient to get us standing to move to maybe a 12B6 motion, but I think past that, to developing the case and presenting it in summary judgment. Same thing on unreasonably burdensome. The complaint, Joint Appendix 34, Joint Appendix 37. The statute does not provide sufficient time for the railroads to conduct an engineering or design review study. That's our allegation in our complaint. We don't have more facts in there yet because we never got past go. And then the need to move the crossings. Railroads routinely modify and upgrade their track, and they need to be able to move these immovable obstructions, and not being able to do so creates an unreasonable burden on interstate commerce. So I totally understand, Your Honor, where you're coming from. This, if we don't have a well-developed factual setting because the whole case got dismissed on standing grounds. So I don't want to keep going well over my time, but if you have any other questions, I mean, we haven't even talked about, there's one set of crossings here where we get zero compensation, which we think is a per se taking, and their claim is that, no, we can go to the commission to get relief. Just look at the statute, Your Honor. You don't need to wait on that. It says, in no set of circumstances can the broadband provider be required to pay a licensing fee. It says what it says. It doesn't create any wiggle room. Same thing with the line that's abandoned.
Doesn't that depend a little bit? I mean, the state says it depends on the scope of the existing easement, right? If they track it directly through an existing easement,
conduit.
it takes nothing.
So I'm not aware of that ever happening, Your Honor. When you think of
But it could, right, and your facial challenge.
So, but it could, that goes to the remedy that we get,
Yeah.
right? It doesn't go to the pleading stage. That's what your court has said. It goes to the remedy that we can seek. So if we can come up with a crazy hypothetical where somebody wants to run a broadband through an existing conduit where they already have an easement, we might need to carve out
But
the
that's
injunction.
that's a reason why takings claims are really not amenable to facial challenges. You have to hypothesize every possible way the property could be taken.
But this one, I agree. I appreciate that, Your Honor, I do. But we have one here where they take it for nothing. I mean, like, it's hard to even imagine a case that we couldn't bring a facial challenge where they say, you have to come onto our property at this public crossing and you get nothing in return, zero. That seems like there's no legal remedy, right? There's no adequacy of remedy.
Their responses, and you can imagine a case where we're not actually taking anything is their response, and it sounds
But
like the state Supreme
But the
Court
whole
will address
statute is
this.
premised on them coming to us for our permission. So if there's a conduit from
But
which they have
nobody's
to operate,
taking anything, and how can you determine the compensation that's due someone?
we
if
know it's
don't
more
have-
than zero, Your Honor.
If we don't have a taking in front of us.
The statute is set up to give us zero compensation. That has got to be a per se taking. If we have any property interest at all, and let me just note on the taking issue in the complaint, if you're going to look to the allegations, the railroads retain fee simple or other property interests above and below their right-of-ways at public crossing locations, period. So that's the allegation that's set
But
forth in the
isn't,
complaint.
this public right-of-way question is one of the very questions before the Virginia Supreme Court right now, isn't it? Isn't that
Well-
it's a public right-of-way crossing in one of those cases?
They're not in the Norfolk Southern case. I can't tell you if they are in the CSX case, but I do believe that all of these issues have been presented to the Virginia Supreme Court. Now, whether you defer and wait on them, I actually don't think there's any reason to. We have a federal challenge of a federal right to bring a case in
But
federal
if
court.
if the question here, if the basic tension here is between facial and as applied,
Yes,
the normal understanding of a facial challenge is to say that in no set of circumstances, we have to wipe out the whole statute, because in no set of circumstances can it be lawfully
Yep.
applied. And.
Can I give you an example, Your Honor, where
Hold on.
that goes to the remedy? And I'll give you one example, and then I'll sit down.
Well, okay, but
The-
I
the-
just,
The railroad industries, the AAR routinely challenges regulations is
But,
preempted.
but how can we say that in no set of circumstances can this be lawfully applied? And that's exactly what a facial challenge
Yes, Your Honor.
normally means. Now, maybe,
So
You know,
let me
that can
try to
be-
answer, Your Honor. First, on discrimination, we have a facial challenge. It's discriminatory in every application. Going to the remedy, routinely, the AAR brings challenges against statutes that regulate rail transportation, and people will come back and say, well, you haven't demonstrated it is unconstitutional in all applications. Why? Because there are a few railroads in the state that aren't subject to the jurisdiction of the Surface Transportation Board. There are a few railroads that don't get any of these protections from the Interstate Commerce Act. And so they'll say, well, you're bringing a facial challenge. We say, no. It's not a facial challenge as it applies to that circumstances. We can craft a remedy that satisfies that fits within our theory of the case. And then you could do that here. We could have a remedy that only focuses on public crossings if you believe that individual participation is necessary or that no set of circumstances would apply to the $2,000 one. Or we can craft a remedy that says it should only apply to, only based on where we can show it's going to be an unreasonably burdensome. Our point is that the discrimination claim shows a facial preemption problem. Our cumulative burden argument, if it's true, which would invalidate the law completely as it applies to regulated railroads. And our takings law, we think the remedy could have been fit to the circumstances of each of the types and categories. And so we should have had standing to at least present that theory as well. Thank you very much. Very much appreciate all the latitude on time.
Judge Harris, do you have anything? Okay, we're fine, thank you.
Thank you, Your Honor.
We'll come down and greet counsel and then move into our final case. Mr. Newton, happy to hear from you.
Thank you. Good morning, and may it please the court. This morning I will address three issues. First, the primary threshold issue upon which both the involuntary guilty plea claim and the ineffective assistance of counsel claim rest, which is whether the definition of interstate and foreign commerce and its exception in 18 U.S.C. section 921A2 defines the phrase commerce in or affecting commerce in 18 U.S.C. 922G. There's also a subsidiary threshold issue, which is, if so, whether the commercial movement of the rifle in this case from its manufacturer in a city in North Carolina, traveling outside North Carolina to a wholesaler and then to a wholesale warehouse of a retailer and then back to the retailer in North Carolina.
But this is not presented to us in the course of a direct appeal or in the course of a sentencing hearing. It's a collateral attack upon a guilty plea. And so the procedural posture of seeking to withdraw a guilty plea is very different from a direct appeal or the sentencing hearing itself. And this question might be raised in another context, but it's raised in the specific context where you face a very high bar.
Your Honor, I would
We don't generally grant motions to withdraw guilty pleas unless, except under certain stringent conditions, and unless something went very basically wrong with the guilty plea proceeding itself.
Something did go very basically wrong with the guilty plea proceeding. If the court agrees with my statutory.
Well, I'm not sure, because your claims have varied all over the lot. There's sometimes they seem to be ineffective assistance of counsel. Sometimes they seem to be egregious governmental misconduct. Sometimes they were raised here but not there, and the rest. In other words, there's the focus of the case seems to be shifting a little bit.
Well, part of that is because there was a pro se litigant in the court below, and the question that the court granted a COA on was one issue, and when I got appointed on the case, I saw there had been a separate issue that was preserved, an ineffective assistance of counsel claim, and I moved the court, and the court granted my motion to expand the COA. So there is a ineffective assistance of counsel claim, and there is an involuntary guilty plea claim. But I'll make this really simple.
I'm sorry, before you make it simple, I want to make it more complicated just for a second. In the petition itself, there was both an ineffective assistance claim, which you are now briefing, and there was sort of a due process guilty plea claim, but that was only based on ineffective assistance.
Not entirely.
It said I'm incorporating everything I said about ineffective assistance, and that is my due process claim.
He also moved to amend. He called it supplement, but it was treated as a motion to amend. And to his credit, he actually cites Rule 15 and says this relates back. And he cites a Fourth Circuit decision, U.S. versus Mastrapa, in which this court, in discussing invalid factual basis, says this bleeds into an involuntariness claim. So construing his pleadings liberally, as this court must, he did raise a independent due process
What is
challenge.
before us? Is it ineffective assistance of counsel before us?
Yes, both are before you under the amended.
What's that?
Both the claims are before you based on the COA that was expanded. But let me explain why, however you want to
What?
view the claim, why this is actually a lot simpler than may appear.
Well,
Sorry, let me I really do just want to understand. So you think there are two claims before us, but I think this was the first thing you said, and I really want to be clear about this. They both rest on the same underlying argument about
Correct.
the jurisdiction. And if, just assuming hypothetically, if the nexus argument doesn't pan out on the merits, then both claims fail.
Correct,
Okay.
correct.
Thank you.
But let me tell you why it does.
Okay.
This is, let me tell you why this is simple. The statute says that, and this assumes that the definition of interstate and foreign commerce defines the term commerce in 922G1. And the legislative history certainly indicates it does. I think just basic.
Wait, what?
The legislative history certainly indicates it does. I quote from a Fifth Circuit case that quotes from the House report, which is the key piece
No,
of
they were
legislation.
two different statutes, right? They originally were two different statutes.
1202 and 922G.
Right. And there's a statutory definition of the term interstate or foreign commerce in one of the statutes. And that term, when the statutes were merged, that term was not added to the clause we're talking about.
The,
Clause we're talking about doesn't use the statutorily defined term.
I submit it
Right,
does.
possess in or affecting commerce.
That's in 922G1. My
Right.
position is the definitions of commerce, definition of commerce, including its exception, in 921A2.
That's not a definition of commerce, that's a definition of interstate or foreign commerce.
Right, but using,
And that phrase is not used in 922G1, possess in or affecting commerce.
using principles
Do you
of-
agree with that?
I disagree with that.
So
I
you
agree
think
with
the
you.
words possess in or affecting commerce also use the words interstate or foreign commerce?
No, but using principles of statutory interpretation, the definition in 921 of interstate and foreign commerce, which is a unitary concept, has to be read to interpret the term commerce.
What is the principle of statutory interpretation that says we use a statutorily defined term, we use that definition when the statutorily defined term is not used?
Well, it is used because the case
No,
law.
they were different statutes. Where this came from, possess in or affecting commerce, there's case law about that. The Supreme Court has opined on what that means.
Under the
They've
con-
said it goes to the limits of the Constitution, it's meant to include everything, and under that original, where it came from, it was specifically defined to include commerce within one state that passes through another state. And that old soil comes with it as it goes over into the new statute, where they don't amend it to include the definition that you want us to add.
So the only way to view the term commerce in 922G1 is to view it the way that it has been talked about for 200 years, which is interstate or foreign commerce. And when Congress defines interstate or foreign commerce to include a specific kind of thing with an exception,
Congress is using a term of art here, in and affecting commerce. And the in and affecting commerce modifies possession. And it has been said too many times to mention that when Congress uses this term of art, it means to extend its jurisdictional powers to its fullest extent. And it would seem a classic case of a possession of a weapon, of a gun that has been in interstate commerce. This is a garden variety 922G claim as far as the jurisdictional element is concerned. If something goes from North Carolina to Louisiana, then to Georgia or wherever, and then back to North Carolina, that gun has moved in interstate commerce. And it's possessed by a felon.
you're talking about the constitutional interpretation under the Commerce Clause. I'm talking about a specific statutory definition
Right,
that
and
defines
that's
an
what-
element.
That's, the words in and affecting commerce are part of the specific statutory definition. And all of this little trip that this weapon took through these different states, all took place prior to the possession of the weapon. And the felon possessed the weapon, and prior, the weapon had moved in interstate commerce, and you might have a different case if a truck was going down an interstate in North Carolina and part of the interstate went 5 or 6 miles, went into South Carolina, and then the truck got back on the interstate in North Carolina, and that was where the possession occurred. Okay, we had to listen to that, but that's not this case. This is a well-traveled weapon. It has been all over the place. It's been to wholesalers, it's been to retailers. If that ain't moving in interstate commerce, then I don't know what is.
Your Honor, I am focused on the plain language of 921A2 that says what's not interstate or foreign commerce is when something moves, quote, between places within the same state, but through any place outside of that state. That's very broad language. That does not talk about it moves briefly into South Carolina and comes back into North Carolina. This was a continuous.
Well, it doesn't, I mean, first we have a problem that the statutory definition you're using is not the words in the statute that we're supposed to be interpreting, right? You're using a definition of a different term, but then also, it doesn't say moving between places. It says commerce between any place in a state and a place outside of that state, but it excludes commerce between places within the same state, but through any place outside of it. So it would seem that that would apply to a transaction that one end and the other end of the transaction are both within the state, but as Judge Wilkinson points out, it makes a little trip outside on its way.
There's nothing about making a little trip in this language. It's very broad. I would note the only court to have interpreted this, it was a gun that went outside of the 3-mile limit in the Atlantic Ocean that belonged to Florida and goes at 15 miles out and later comes back in. Might be deemed a little trip compared to what this weapon took, but there's
No,
no,
there are
there's
these,
no way
there-
to limit them.
There are attacks on all these gun laws. Second Amendment attacks, this kind of attack. I know the 922 series, 922G is the most important. It is the linchpin. And your claim seeks to dismember, and it would have far-reaching implications on the provision in the 922G series, which is probably its most important. And that's okay if you want to bring that kind of claim, but the problem is it's in the face of a congressional term in and affecting commerce where Congress wished to extend its jurisdictional authority to the fullest. And I can't imagine how this would seem as a matter of statutory interpretation if we were to say, oh, well, something that's been in North Carolina, and then went to Georgia, and then went to Louisiana and everything. It never moved in interstate commerce. I mean, that ain't gonna pass a straight face
we're
test. Yes,
talking
it
two
did move in interstate commerce.
Your Honor, we're talking two different languages. You're talking constitutional commerce clause language. I'm talking
Can I ask you
statutory.
about statutory interpretation? Do you agree that there is a principle, statutory interpretation, that when Congress uses a term in one place but not in another place, it uses different language, we are supposed to look at that with the assumption that Congress meant
Inclusio unius
different
exclusio
things.
alterius, which there's another one.
your Latin is so great.
In para materia.
Right, so when Congress uses a term in one place but not in the other place, that's supposed to mean something.
Well, there are two competing statutory
Do you agree,
interpretation
do you agree with
principles.
that?
If that were being viewed in isolation, I would, but there's a competing one, which is in para materia. We also have legislative
But
history.
in para materia doesn't mean we read Congress to say something it doesn't say. So in the statute, it says it's unlawful for felons to ship or transport in interstate or foreign commerce. It's also illegal to receive any firearm or ammunition that has been shipped or transported in interstate or foreign commerce. But it's illegal to possess in or affecting commerce. They didn't use interstate or foreign commerce, the defined term there. And the Supreme Court tells me that's supposed to mean something.
Well, there is no other commerce.
Do you agree with that?
I disagree with your interpretation of the.
You think I should read all of them to say the same thing, even though Congress made them say different things?
I do, and I do because there is no such thing as non-interstate or
Sure
foreign
there
commerce.
is.
That's commerce.
We're arguing about the very thing that is commerce, but is not the statutorily defined interstate or foreign commerce. It can be commerce, even though it comes back to the same state, right? It passed through another state. We're arguing about the exception, right?
Correct.
You're pinning everything on the definitional exception.
That's correct.
That exception doesn't apply to the constitutional limits of intersecting commerce. We know that because the Supreme Court has told us it just has to have any touch with
If I-
interstate commerce.
Really quickly, this is a one-off case. You made the comment, Judge Wilkinson, that this was
Sure, you
going to.
can answer Judge Rushing's question.
Sure. I take the position that using established principles of statutory interpretation in para materia and the legislative history, which supports what I'm saying, that Congress intended all this to be one unitary concept, interstate and foreign commerce, and the fact they didn't put the terms interstate and foreign before the term commerce at the end of 922G1 doesn't change anything.
To the
That-
contrary, doesn't the legislative history seems to suggest it was very purposeful not to add that term here, because they were taking the possession statute from a different place in the code And they wanted to take all of the law that surrounded that place in the code and move it here when they consolidated it, right? The history suggests it was very intentional to leave this definitional term out.
I don't read the legislative history that way. I think this was a relatively quickly done thing in 1968 that took some things and didn't take other things. But what they did clearly do was add the word not in the definition in 921A2 that did not exist in the predecessor statute, section 1202.
To define interstate or foreign commerce.
Correct, which
Yeah.
I contend has to be read to define the term commerce in 922G. Let me quickly say, this is not going to have a huge implications for other cases. This is a one-off. I have found no other case where a person possesses a gun manufactured within their state that made a commercial trip to the wholesaler in the retailer's warehouse and then back to a retailer in the state. That's probably never happened in one other than this case, and it'll probably never happen again.
Thank you, counsel.
Thank you.
Ms. Greenaw?
May it please the court. Elizabeth Greenup on behalf of the United States. This court should affirm the district court's denial of Mr. Irvin's 2255 motion to vacate his felon in possession of a firearms conviction. I think you've hit on the main point here, and my opponent has agreed that if you find that the language.
Is this claim even properly before us, or has it been forfeited?
So I don't think it's properly before the court, no. And when he's talking about the relation back to his original motion to vacate, one, I don't think he made the claim below.
Was it raised in the sentencing? Was it raised in the guilty plea hearing? Was it raised on direct appeal? Was it?
No.
I don't even know if it was raised before the district court. But is this claim, is the claim forfeited as a procedural matter?
I believe it is, Your Honor, because.
Do you think his ineffective assistance is
Not
forfeited?
the ineffective
Okay.
assistance, I'm sorry, the guilty plea
Okay.
claim, yes, no, I don't, his
Well, they
ineffective
both
assistance
rely
claim-
on the guilty plea, right? We're talking about the statute because it goes to prejudice and whether he would have had any reason not to plead guilty,
Right,
whether as to the IAC claim or to this, due process claim.
right, and they're given,
I'm so sorry, but, I mean, we wouldn't be here but for this false ATF report. Putting to one side the legal question of whether it's egregious misconduct that would allow for withdrawal of a plea, just what happened? How did ATF get this so wrong?
so it's not in the record, I can probably answer your question if you'd like me to.
I would be encouraged if I thought this was we'll talk about a one-off, that this was a one-off blunder that will not recur.
Yes, this is the only time I've heard of this. My understanding, the research was based on prior research the agent had done. And this was a relatively new gun manufacturing plant
Okay.
in North Carolina. So I think
Okay.
this was a very limited situation. It's unfortunate. But at the end of the day, Irvin received, by pleading guilty, he received a 3-level reduction in his acceptance of responsibility, which reduced his applicable guidelines range by 6 years. So there would have been no reason for him to go to trial to argue that his conduct after this semi-automatic weapon moved to Louisiana and then to Georgia and back to North Carolina, that didn't affect interstate commerce, that it was not in or affecting commerce under the statute. And I do believe that the clear language, the plain language of the text of the statute controls here. I do want to mention one thing with respect to the legislative history. When this statute was originally enacted in 1202, there was a definition there of commerce, not of interstate commerce, but of commerce. And that included travel between points within the state through another state, so through another area. So I do think that, and it's I believe the Fifth Circuit case where,
I mean, even if we get to the guilty plea, or to the fact that this is cognizable, for the life of me, I can't see the actual innocence that's necessary to prove prejudice or that's necessary to make the claim fly. I may be very simplistic, but to me, Louisiana and Georgia and North Carolina are different states. Last time I checked the atlas. And the gun went through all three of them. And the idea that Congress might not have meant to cover this when it used the phrase in or affecting commerce, which extends its jurisdictional authority. It all took place before the possession. The timing of it is significant. It took place before the possession took place. He was lucky, and this doesn't pertain to what I think is a relatively simple application of 922G. But people sometimes seem to withdraw guilty pleas out of a sense of buyer's remorse or whatever. And it is an oddity to this that we are talking about ineffective assistance of counsel when you look even at the performance prong under Strickland v. Washington. I realize it doesn't touch the jurisdictional question, but it's just one of those ironies about where we are these days, that this lawyer, as far as I can see, did one heck of a good job. He reduced the guidelines range by 6 years. He got a reduction, offense level reduction for acceptance of responsibility. He served his client, or she served her client well. And yet we're up here on an ineffective assistance of counsel claim with an actual innocence claim that's supposed to prove prejudice from what was the effective representation of counsel, and in the face of travel. If a family goes on a vacation and they go around state lines, they went to Georgia and Louisiana and said, and somebody asked when they come back to the place that they left for vacation, and said, "Oh, how was your trip? Did you travel interstate?" And they would look at you as if you were crazy. Of course, we got in the family car. We went down to Georgia. We went down to Louisiana. The answer would be to that family that came back to the place from where they started their vacation. Yeah, well, of course, what do you mean did we go interstate? We crossed the state lines, went from one to another. That's the itinerary that the gun pursued.
Right.
So that it's just odd. I come back, I realize the question can be said, well, you need to prove innocence, and he's saying jurisdictionally I'm innocent and everything. But still, there is an oddity here that a lawyer who did a good job for the client, and as a guilty plea, as far as I can tell, it was voluntary and intelligent. He was represented by counsel. It was and all the rest, and he's asking to withdraw it. And, I don't get it.
Well, I guess I sort of get it. I think the concern, right, is that well, I guess I should maybe ask it this way, is the government's position that a lawyer should just be able to rely on an ATF report? I mean, that would be the concern, right? That the lawyer should have checked the ATF report, found out it was false, and then might have done further research indicating that it didn't really matter that it was false because the jurisdictional nexus was otherwise satisfied. But I think the defendant's concern here is, as far as I can tell, my lawyer just took the government's word for the fact that an essential element of the offense was satisfied.
Right. And I do think it would fall within the wide range of reasonable professional assistance for an attorney to rely on an ATF report that's provided by the government.
I know, but then that
Because-
makes it so much worse that this one was false.
But the fact that it's extraordinarily rare, I
Well, we
think,
hope, I mean.
as I said, this is the only one I've heard of. But I do think that, there's no evidence here that there was anything egregiously wrong, that anyone was out to get this defendant, that they wanted to deliberately create a report or something. So if there's some concern that there's a target of an individual, then you
I
have.
guess I'm thinking of it more in terms of ineffective assistance, and just wondering, like, maybe in a state where there is a manufacturer of guns, if you get the ATF report that says this gun was not manufactured in North Carolina, that's the one thing we know, like, maybe a defense lawyer should check that, like, do a Google search, put in the manufacturer of the gun and see if they're in North Carolina. I'm anxious about the combination of your instinct, which I share, that, look, a defense lawyer ought to be able to rely on an ATF report about where a gun was manufactured, and the fact that in this case, that would have been incorrect.
Right. So, I mean, the issue, I guess, is that you have to have counsel who is effective. And the question is whether or not it would have been reasonable for the attorney to take that at its face value, or whether they have to investigate it. And that's something, that would be more of a factual issue, I guess, to decide. But I think we assume that attorneys, the presumption is that they act within their within their discretion, and then we presume that they're acting accordingly. So,
Did you make an argument about the effectiveness prong on appeal? I didn't think the effectiveness prong was being debated.
so the deficiency prong.
Sorry,
Right.
the deficiency prong, yeah.
Right. I did not
It's just
actually.
the prejudice prong was being debated.
Right. I think the prejudice prong is very, very strong, and I think, as you're pointing out, Judge Harris, there may be more issues that might, be something you would want
We would hope that
to get
the
more
fe-
evidence on, but
We would
I-
hope that the federal defenders updated the information about North Carolina once they realized, oh, there is a new manufacturing facility, we're going to stop. We're going to start checking for this, right?
I'm sure they're double checking.
Yeah.
So, yes, I think the prejudice prong is very strong. I do think, like I said, that it would have fallen within the wide range of reasonable professional assistance. I do understand your concern there, but I do think that that's where you bring your ineffective assistance claim, and if there's something to it, then the court can correct it. But here, if the attorney, and we don't know what the attorney did, but if he had investigated it, he would have discovered it moved in interstate commerce. So at the end of the day, his advice to the defendant should have been the same. There's no viable defense here, so you're better off pleading guilty and getting that 6-year reduction for acceptance of responsibility. And then his attorney noted at sentencing too that, well, he called it having super acceptance of responsibility, but said he wanted to plead guilty to get home quickly to his family. So there were considerations that were taken into account there with the plea. If there are no further questions, I'm happy to ask the court to affirm the district court's judgment.
Judge Harris, do you have further questions? Thank you very much.
Thank you.
Mr. Newton, some rebuttal time, sir.
Thank you. Your Honor, Judge Wilkinson, you made the comment about what if you were to travel out of state on vacation and you come home and your friends say, well, how was your interstate trip? And of course they traveled interstate, right? I'm not saying in the common parlance a person wouldn't travel interstate. And I'm not saying Congress wouldn't have the constitutional authority in that case to regulate that. The real question to ask that couple would be, did you enjoy your trip that traveled between places within the same state, but through any place outside of that state? And if that language includes leaving the state that you begin in one place and making a commercial trip through however many states, but with the coming back to that state, that is arguably within the language, the plain language of that provision. Again, this is novel. I'm not saying it's not novel because it's such a weird fact pattern. I was an assistant federal public defender for 13 years. I handled several dozens of these 922G cases. That, you're right, they're a staple of federal prosecution. I will tell you what I always did, even if it just took me 5 minutes, was verify.
We're hearing a little vouching here.
Yeah, well, just to verify where the gun was made. That's just, I would also check to see if my client was a felon, because sometimes they weren't. They were a misdemeanor or whatever. This was deficient performance. The question is, was it prejudicial? And whether it's prejudicial is going to turn on whether you agree that my statutory interpretation is correct. If you disagree with it, then I lose. If it is an arguable statutory interpretation, I believe it's more than arguable, using the tools of statutory interpretation. There are two kinds of commerce. There's the kind of commerce Congress can regulate, and there's the kind of commerce Congress cannot regulate. Intrastate, look, if this gun had never traveled outside of North Carolina and he had possessed it, this would not be a federal prosecution. Maybe be a state prosecution, but not a federal prosecution. It's the intrastate is not something that falls within 922G. It has to be inter-affecting commerce, and that definition of commerce is foreign, is interstate or foreign commerce. It is a very reasonable interpretation of 921A2 to read the definition of interstate and foreign commerce as impermateria of commerce in 922G1. If I am correct,
You're adding terms, are you not?
no, the
Yes, you
terms
are.
interstate and foreign are built into the word commerce in 922G1.
But
So
you-
by
you
saying they're
seem
built
allergic.
in, you're saying they're not there.
They're implicit.
Right, implicit means not there, not explicit, not on the page,
There are
not written in black and white.
No, but there are countless Supreme Court of the United States decisions that, in interpreting statutes, will read words as implicit under the context of the statute.
Oh,
That-
this is implicit in the context of that. I mean, that's would be a no-no at the Supreme Court.
I disagree.
You see, I know you disagree, but I'm saying, you seem allergic to the phrase in or affecting commerce. I've listened carefully to your argument, and you seem to be shying away from the use of that phrase or its import throughout. And then we ask why, and you say, well, it's implicit in the context of the statute. We're supposed to overrule an explicit expression for implicit context? I
Judge-
mean, how does that, because that was your response.
Judge, I'm not shying away. I am acknowledging that if, as a matter of constitutional law, that the gun traveled in interstate commerce. I am making a very specific argument based on the language of the statute and,
Oh, so now we're gonna have a big constitutional issue, huh?
no, I'm not making a.
I thought you just said so.
No, I'm saying I'm not disputing the constitutional implications of the guns travel. I'm arguing under 921A2, the definition, which I contend, and under established principles of statutory interpretation, which
But wasn't, I mean, Scarborough, you're talking about constitutional principles. Scarborough was interpreting in or affecting commerce.
it was interpreting 1202.
Yeah,
It didn't
in or affecting commerce, the exact words we are talking about
The
here.
definition that I'm talking about didn't exist in 1202. So
Right,
Scar-
because it's a definition for a different term. But the term in or affecting commerce is exactly what the Supreme Court was talking about in Scarborough, right? And they said it goes to the bounds of the Constitution.
They talked about it as a matter of constitutional law. They had no reason to interpret 921A2 because
Right.
it didn't exist in that statute.
Yeah, and because it's different words.
All right,
All right, thank you.
hold on, Judge. Judge Rushing. Thank you. Mr. Newton, I would like to thank you on behalf of the court. I see that you're court appointed, and I think you presented a fine argument, and I'd just like to express the appreciation of all three of us for your services. We'll adjourn court and come down and greet counsel, and thanks to our courtroom deputy as well. You made things run very smoothly.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.